A few citations from the ample and excellent headnotes to the first 2 chapters of the work answer the inquiry. They run thus. The Landesgemeinden of Uri and Appenzell, their bearing on English constitutional history, political elements common to the whole Teutonic race, monarchic, aristocratic, and democratic elements to be found from the beginning, the 3 classes of men, the noble, the common freeman, and the slave, universal prevalence of slavery, the Teutonic institutions common to the whole Aryan family, witness of Homer, description of the German assemblies by Tacitus, continuity of English institutions, English nationality assumed, Teutonic institutions brought into Britain by the English conquerors, effects of the settlement on the conquerors, probable increase of slavery, earls and churls, growth of the kingly power, nature of kingship, special sanctity of the king, immemorial distinction between kings and ealdormen, gradual growth of the English constitution, new laws seldom called for, importance of precedent, return to early principles in modern legislation, shrinking up of the ancient national assemblies, constitution of the Wettergemote. The Wettergemote continued in the House of Lords, Gemotes after the Norman conquest, the King's right of summons, life peerages, origin of the House of Commons, comparison of English and French national assemblies, of English and French history generally, course of events influenced by particular men, Simon of Montfort, Edward I, the constitution finally completed under him, nature of later changes, difference between English and continental legislatures. All this is interesting, erudite, full of historical importance, and thoroughly in its place in a book concerned solely with the growth of the Constitution, but in regard to English law and the law of the Constitution, the Landesgemeinden of Uri, the witness of Homer, the ealdormen, the Constitution of the Wettergemote, and a lot more fascinating matter are mere antiquarianism. Let no one suppose that to say this is to deny the relation between history and law. It were far better, as things now stand, to be charged with heresy than to fall under the suspicion of lacking historical mindedness, or of questioning the universal validity of the historical method. What one may assert without incurring the risk of such crushing imputations is, that the kind of constitutional history which consists in researches into the antiquities of English institutions has no direct bearing on the rules of constitutional law in the sense in which these rules can become the subject of legal comment. Let us eagerly learn all that is known, and still more eagerly all that is not known, about the Wettergemote. But let us remember that antiquarianism is not law, and that the function of a trained lawyer is not to know what the law of England was yesterday, still less what it was centuries ago, or what it ought to be tomorrow, but to know and be able to state what are the principles of law which actually and at the present day exist in England. For this purpose it boots nothing to know the nature of the Landesgemeinden of Uri, or to understand, or if it be understandable, the constitution of the Wettergemote. All this is for a lawyer's purposes simple antiquarianism. It throws as much light on the Constitution of the United States as upon the Constitution of England. That is, it throws from a legal point of view no light upon either the one or the other. The name of the United States serves well to remind us of the true relation between constitutional historians and legal constitutionalists. They are each concerned with the Constitution, but from a different aspect. An historian is primarily occupied with ascertaining the steps by which a constitution has grown to be what it is. He is deeply, sometimes excessively, concerned with the question of origins. He is but indirectly concerned in ascertaining what are the rules of the Constitution in the year 1908. To a lawyer, on the other hand, the primary object of study is the law as it now stands. He is only secondarily occupied with ascertaining how it came into existence. This is absolutely clear if we compare the position of an American historian with the position of an American jurist. The historian of the American Union would not commence his researches at the year 1789. He would have a good deal to say about colonial history and about the institutions of England. He might, for aught I know, find himself impelled to go back to the Wettergemote. He would, one may suspect, pause in his researches considerably short of Uri. A lawyer lecturing on the Constitution of the United States would, on the other hand, necessarily start from the Constitution itself, but he would soon see that the Articles of the Constitution required a knowledge of the Articles of Confederation, that the opinions of Washington, of Hamilton, and generally of the Fathers, as one sometimes hears them called in America, threw light on the meaning of various constitutional articles, and further that the meaning of the Constitution could not be adequately understood by anyone who did not take into account the situation of the colonies before the separation from England and the rules of common law, as well as the general conceptions of law and justice inherited by English colonists from their English forefathers. As it is with the American lawyer compared with the American historian, so it is with the English lawyer as compared with the English historian. Hence, even where lawyers are concerned, as they frequently must be, with the development of our institutions, arises a further difference between the historical and the legal view of the Constitution. Historians, in their devotion to the earliest phases of ascertainable history, are infected with a love which, in the eyes of a lawyer, appears inordinate, for the germs of our institutions, and seems to care little about their later developments. Mr. Freeman gives but 1/3 of his book to anything as modern as the days of the Stuarts. The period of now more than 2 centuries which has elapsed since what used to be called the Glorious Revolution, filled as those 2 centuries are with change and with growth, seems hardly to have attracted the attention of a writer whom lack, not of knowledge, but of will has alone prevented from sketching out the annals of our modern constitution. A lawyer must look at the matter differently. It is from the later annals of England he derives most help in the study of existing law. What we might have obtained from Dr. Stubbs had he not surrendered to the episcopate gifts which we hoped were dedicated to the university alone is now left to conjecture. But, things being as they are, the historian who most nearly meets the wants of lawyers is Mr. Gardiner. The struggles of the 17th century, the conflict between James and Coke, Bacon's theory of the prerogative, Charles' effort to substitute the personal will of Charles Stuart for the legal will of the King of England, are all matters which touch not remotely upon the problems of actual law. A knowledge of these things guard us, at any rate, from the illusion, for illusion it must be termed, that modern constitutional freedom has been established by an astounding method of retrogressive progress, that every step towards civilization has been a step backwards towards the simple wisdom of our uncultured ancestors. The assumption which underlies this view, namely, that there existed among our Saxon forefathers a more or less perfect polity, conceals the truth both of law and of history. To ask how a mass of legal subtleties, quote, would have looked in the eyes of a man who had borne his part in the elections of Edward and of Harold, and who had raised his voice and clashed his arms in the great assembly which restored Godwin to his lands, end quote, Freeman, is to put an inquiry which involves an untenable assumption. It is like asking what a Cherokee Indian would have thought of the claim of George III to separate taxation from representation. In each case, the question implies that the simplicity of a savage enables him to solve with fairness a problem of which he cannot understand the terms. Civilization may rise above, but barbarism sinks below the level of legal fictions, and our respectable Saxon ancestors were, as compared, not with ourselves only, but with men so like ourselves as Coke and Hale, respectable barbarians. The supposition, moreover, that the cunning of lawyers has by the invention of legal fictions corrupted the fair simplicity of our original constitution underrates the statesmanship of lawyers as much as it overrates the merits of early society. The fictions of the courts have in the hands of lawyers such as Coke served the cause both of justice and of freedom, and served it when it could have been defended by no other weapons. For there are social conditions under which legal fictions or subtleties afford the sole means of establishing that rule of equal and settled law which is the true basis of English civilization. Nothing can be more pedantic, nothing more artificial, nothing more unhistorical than the reasoning by which Coke induced or compelled James to forego the attempt to withdraw cases from the courts for his Majesty's personal determination. But no achievement of sound argument or stroke of enlightened statesmanship ever established a rule more essential to the very existence of the Constitution than the principle enforced by the obstinacy and the fallacies of the great Chief Justice. Oddly enough, the notion of an ideal constitution corrupted by the technicalities of lawyers is at bottom a delusion of the legal imagination. The idea of retrogressive progress is merely one form of the appeal to precedent. This appeal has made its appearance at every crisis in the history of England, and indeed no one has stated so forcibly as my friend Mr. Freeman himself the peculiarity of all English efforts to extend the liberties of the country, namely, that these attempts at innovation have always assumed the form of an appeal to pre-existing rights. But the appeal to precedent is in the law courts merely a useful fiction by which judicial decision conceals its transformation into judicial legislation, and a fiction is none the less a fiction because it has emerged from the courts into the field of politics or of history. Here, then, the astuteness of lawyers has imposed upon the simplicity of historians. Formalism and antiquarianism have, so to speak, joined hands. They have united to mislead students in search for the law of the Constitution. Let us turn now to the political theorists. No better types of such thinkers can be taken than Bagehot and Professor Hearne. No author of modern times, it may be confidently asserted, has done so much to elucidate the intricate workings of English government as Bagehot. His English Constitution is so full of brightness, originality, and wit that few students notice how full it is also of knowledge, of wisdom, and of insight. The slight touches, for example, by which Bagehot paints the reality of cabinet government are so amusing as to make a reader forget that Bagehot was the first author who explained in accordance with actual fact the true nature of the cabinet and its real relation to the Crown and to Parliament. He is, in short, one of those rare teachers who have explained intricate matters with such complete clearness as to make the public forget that what is now so clear ever needed explanation. Professor Hearne may perhaps be counted as anticipator of Bagehot. In any case, he too has approached English constitutions from a new point of view and has looked at them in a fresh light. He would be universally recognised among us as one of the most distinguished and ingenious exponents of the mysteries of the English Constitution, had it not been for the fact that he made his fame as a professor, not in any of the seats of learning in the United Kingdom, but in the University of Melbourne. From both these writers we expect to learn, and do learn much, But, as in the case of Mr. Freeman, though we learn much from our teacher which is of value, we do not learn precisely what as lawyers we are in search of. The truth is that both Bagehot and Professor Hearn deal and mean to deal mainly with political understandings or conventions and not with rules of law. What is the precise moral influence which might be exerted by a wise constitutional monarch? What are the circumstances under which a minister is entitled to dissolve Parliament? Whether the simultaneous creation of a large number of peers for a special purpose is constitutionally justifiable? What is the principle on which a cabinet may allow of open questions? These and the like are the kind of inquiries raised and solved by writers whom, as being occupied with the conventional understandings of the Constitution, we may term conventionalists. These inquiries are, many of them, great and weighty, but they are not inquiries which will ever be debated in the law courts. If the Premier should advise the creation of 500 peers, the Chancery Division would not, we may be sure, grant an injunction to restrain their creation. If he should on a vote of censure decline to resign office, the King's Bench Division would certainly not issue a quo warranto calling upon him to show cause why he continues to be Prime Minister. As a lawyer, I find these matters too high for me. Their practical solution must be left to the profound wisdom of members of Parliament. Their speculative solution belongs to the province of political theorists. One suggestion a mere legist may be allowed to make, namely, that the authors who insist upon and explain the conventional character of the understandings which make up a great part of the Constitution, leave unexplained the one matter which needs explanation. They give no satisfactory answer to the inquiry how it happens that the understandings of politics are sometimes at least obeyed as rigorously as the commands of law. To refer to public opinion and to considerations of expediency is to offer but a very inadequate solution of a really curious problem. Public opinion approves and public expediency requires the observance of contracts, yet contracts are not always observed, and would, presumably, be broken more often than they are, did not the law punish their breach or compel their performance. Meanwhile, it is certain that understandings are not laws, and that no system of conventionalism will explain the whole nature of constitutional law, if indeed constitutional law be in strictness law at all. For at this point a doubt occurs to one's mind which must more than once have haunted students of the Constitution. Is it possible that so-called constitutional law is in reality a cross between history and custom which does not properly deserve the name of law at all, and certainly does not belong to the province of a professor called upon to learn or to teach nothing but the true indubitable law of England? Can it be that a dark saying of Tocqueville's, "The English Constitution has no real existence, elle n'existe point," contains the truth of the whole matter? In this case, lawyers would gladly surrender a domain to which they can establish no valid title. The one half of it should, as belonging to history, go over to our historical professors. The other half should, as belonging to conventions which illustrate the growth of law, be transferred either to my friend the Corpus Professor of Jurisprudence, because it is his vocation to deal with the oddities or the outlying portions of legal science, or to my friend the Chichel Professor of International Law, because he, being a teacher of law which is not law, and being accustomed to expound those rules of public ethics which are miscalled international law, will find himself at home in expounding political ethics which, on the hypothesis under consideration, are miscalled constitutional law. Before, however, admitting the truth of the supposition that constitutional law is in no sense law at all, it will be well to examine a little further into the precise meaning which we attach to the term constitutional law, and then consider how far it is a fit subject for legal exposition. Constitutional law, as the term is used in England, appears to include all rules which directly or indirectly affect the distribution or the exercise of the sovereign power in the state. Hence, it includes, among other things, all rules which define the members of the sovereign power, all rules which regulate the relation of such members to each other, or which determine the mode in which the sovereign power or the members thereof exercise their authority. Its rules prescribe the order of succession to the throne, regulate the prerogatives of the chief magistrate, determine the form of the legislature and its mode of election. These rules also deal with ministers, with their responsibility, with their spheres of action, define the territory over which the sovereignty of the state extends, and settle who are to be deemed subjects or citizens. Observe the use of the word rules, not laws. This employment of terms is intentional. Its object is to call attention to the fact that the rules which make up constitutional law, as the term is used in England, include two sets of principles or maxims of a totally distinct character. The one set of rules are in the strictest sense laws, since they are rules which, whether written or unwritten, whether enacted by statute or derived from the mass of custom, tradition or judge-made maxims known as the common law, are enforced by the courts. These rules constitute constitutional law in the proper sense of that term, and may for the sake of distinction be called collectively the law of the Constitution. The other set of rules consist of conventions, understandings, habits, or practices which, though they may regulate the conduct of the several members of the sovereign power, of the ministry, or of other officials, are not in reality laws at all, since they are not enforced by the courts. This portion of constitutional law may, for the sake of distinction, be termed the conventions of the Constitution, or constitutional morality.